Hi, this week we are talking 5 common contract mistakes that I see and how to avoid them. First, number 1, biggest issue I see, not having a contract. Seriously, it happens so frequently you wouldn't realize, even in the business world. This isn't necessarily just between vendors or customers, but between business partners, with leases, all kinds of things that should be written down, agreed to, and signed are not. I don't care how much you and your customer love each other. You're not doing this on a handshake. You need to write it down, you need to sign it. There's a concept in contract law called the 4 quarters of the document, meaning whatever is on this page and is signed and agreed to, that's the terms and conditions you're working under. All those emails back and forth where you're saying, yeah, sure, what do you think, maybe, oh, and the one accidentally gets deleted and it's not there. No, don't be messing with that. I know in this digital age, we feel like we have a paper trail, but actually putting everything in writing, on paper, reading it, understanding it, signing it is vital to the success of your business, so that when there is an issue, because let's be real, there's going to be an issue, you have a document that you can stand behind. Second biggest mistake I see is contracting with the wrong entity. So you do actually put things in writing, but maybe you say this is between individual A and individual B, when really individual B is the sole member of an LLC, and you want the LLC to do the work, not the individual. Or worse, an individual signs it and happens to just be an employee of a company and doesn't actually have the authority to sign for that company, and therefore your contract might not be valid because that company didn't sign for it. This also comes up when there are parents and subsidiary companies, when there are related companies, affiliates, joint ventures. Just please make sure that you understand who you're contracting with and make sure that the contract is actually written with that entity. Third biggest mistake I see is not tying provisions together. We talked a lot about this in my risk mitigation presentations in October. None of these provisions exist in a vacuum. Your risk does not exist in a vacuum. You have to tie it all together. Contracts, at their heart, are allocations of risk. Make sure that risk is spread out correctly in all of your provisions, especially your warranty, your limit of liability, your indemnity, and your insurance. Make sure you know who you're indemnifying, if your insurance will cover it, does your insurance cap the limit of liability, what type of warranty are you giving, and is it covered by your insurance? Again, it all works together. When you use a DIY form or you Google something off the internet, you have no guarantee that those provisions work together. Most likely they're gonna conflict with each other and you might as well not have had anything. Go back to number 1, it's not good. Fourth, this is something we've talked a little bit about, but not considering the choice of law. So what law governs the contract? Totally up to you and your partner or whoever you're contracting with. However, it really does matter. States, all 50 states have different laws that apply in different ways. And if it's not allowed in the state that you chose for your choice of law, well, then you're out of luck. That provision is going to be taken out of your contract. The rest of it might still stand, but does it work without that? This is a small example, but in California, they actually do not allow you to waive a jury trial until you get to trial. Here in Texas, that's allowed, and I actually suggest to the vast majority of my business clients that they include a provision that you're waiving a jury trial. You really do not want to put your business disputes in front of a jury, trust me. If you want to know why, I can explain it to you, but you just don't want it. But you can't include that in California. Now, in this situation, the worst that happens is that provision gets taken out and not applied. But there are other examples that I can give you where that happens, and that provision actually does affect the business decision being made. So again, make sure you know if you've just randomly chosen Delaware out of the air, because you've heard that Delaware is great for businesses, that you know what the law in Delaware is that applies to this contract. Finally, the biggest mistake I see is not writing clear or complete scopes of work. And I'm not necessarily talking about master services agreement scope of work. I'm just saying this contract is telling you and the third party what you are agreeing to do. If you don't make that clear and if you don't make it complete, it's kind of worthless. You really need to include all the provisions, everything you talked about. Get down into that nitty gritty. It's okay to say, you are doing all these things, I am doing all these things. If we get into an argument, here's what we're gonna sit down and do this, and then this, and then this. Yes, it gets long, yes, it gets wordy, but if you know and it's written and someone else can understand, it is much easier to enforce, and it actually reduces disputes when you have it all written out in a clear and complete manner. So again, contracts are super important. They are not something to mess with if you don't understand the provisions. Please reach out to me, Kelsey at SchaffnerPLLC.com. I'm here to help you with all of your small business contract needs.